fixed rate will be paid in all cases, although if lawyers do 3 times the usual amount of work, they will be paid extra. The prosecution say the fees are reasonable and will allow an efficient firm to profit. The defence say that the cases are not sufficiently similar for fixed fees to be appropriate. The prosecution say that in no other field do professionals get paid by the hour these days, or at least not respectable ones. The defence insists that for a quality job, it is necessary for lawyers to be paid for the work they have done. The prosecution submit that quality standards will be met by a system of peer review, but the defence say this will not prevent a drop in quality. It will just tell you after that the drop occurred. In short, the defence say that fixed fees will mean criminal firms face a reduction in income of 25% of their monthly turnover. An estimated 800 firms will have to close. Certain complex cases may not be taken on because it will be impossible to do them properly under the new system, or that if they are taken on, fee earners will be under pressure to do either more unpaid work or to cut corners. The most vulnerable clients who require extra time and attention will suffer. Now, members of the jury, we turn briefly to the Legal Services Bill, published in November 2006, which sets out the government's legislative proposals to reform the way legal services are regulated and delivered. A Legal Services Board, whose chairman will be appointed by the Lord Chancellor, will oversee the roles of the Law Society and the Bar Council. The defence claim the bill will allow undue influence by the government on the work of legal aid lawyers representing clients against the state. The prosecution, on the other hand, say that the legal profession has been in need of proper regulation for years and that this is an appropriate solution. The bill also allows lawyers and non-lawyers to form legal partnerships and companies, and also to diversify into other business interests. The prosecution submit that it will provide improved competition and a better service for all, whilst the defence say this will inevitably cause conflicts of interest. Finally, members of the jury, what about the recent introduction of means testing in the Magistrates' Court? It was designed to ensure that those able to afford the cost of their own representation should not benefit from legal aid. The prosecution submit that this is a logical way to manage an overstretched budget. The defence, however, say that it saves just £35 million a year, and up to 3/4 of adults in working households are now ineligible for legal aid. Members of the jury, throughout this trial we have heard from a lot of establishment figures and civil servants. But what do the younger members of the legal profession say? We heard evidence from a newfangled group called Young Legal Aid Lawyers. You may think their evidence was entirely credible and persuasive. They showed us the results of a little survey they had done of their membership. They told us that 95% of respondents believe the Carter Review will deter young lawyers from entering the profession. 59% admitted that the Carter reforms had given them cause to consider alternative careers. 1/3 of respondents did not believe they would be working in legal aid in 5 years' time. But why is this, members of the jury? Why? Quite simply, they said that young lawyers will not be able to afford to do legal aid. Almost 2/3 of respondents had personally spent on average £20,000 on training to be a legal aid lawyer. 1/3 say they owe between £10,000 and £20,000 as a result of their education and training. Secondly, young lawyers believe they will not be able to secure training contracts or pupilages and subsequent work because legal aid firms will not be able to afford to take trainees or to spend time training them. In any case, a paralegal will work better to an economies of scale model. Most importantly, young lawyers say they will not want to work in an unstable environment in which they are under pressure to do as many cases as possible and will feel restricted in the work they can do for clients. But why? Apparently, They say that the reason they have become legal aid lawyers is to work towards a more just society. Can you believe it? But as you well know, the prosecution dismissed it, noting that young lawyers were wrong to feel so gloomy about the future, that under the new changes, larger practices would be able to accommodate more trainees, and that it is difficult to build a career in many jobs these days. But the defence called their survey evidence and relied heavily upon it. So, members of the jury, lawyers and the legal aid system stand charged with inefficiency, wasting taxpayers' money, being fat cats who feed off scoundrels. Lawyers are told not to be so gloomy. Are lawyers, in fact, both fat and gloomy? I, for one, have not got to where I am today by being fat or gloomy, and if I may say so, quite the opposite, although obviously I cannot speak for my learned colleagues on the bench. But you have heard enough from me. It now falls to learned defence counsel to present their closing speeches, which of course will be a shining example of efficiency. Beyond 15 minutes, you will hear my hammer and quite possibly my snores.